Good evening to you all and welcome to Law of Sea and Maritime Law course again. So today we will start with the lecture series from week 3rd onwards and today it will be lecture 5. Now in our previous discussion we have widely discussed about the states, the transit passage to the state and the kind of rights the coastal state or let's say the neighboring states do have vis-a-vis the rights of the free movement of the ship which the ship owner does have or uh, any such nation that owns that ship does have. So in that reference, how law of sea plays its role for balancing the rights between the two parties and also the restrictions on or the limitations on the rights that are put on that of the coastal states. So today we will just give a cursory look to island and archipelago and then we will continue with a very important case that was dealt with by the dispute settlement body of UNICOR. So what is archipelago and what is island? Basically archipelagos are smaller than that of island but they are in groups. So whereas island usually is a sole body of land that is found in the sea area or let's say the oceans or even when we use this term also when there is a big river. So, but anyway, the features of the archipelago and island are same except that archipelago is quite small in comparison to that of the island. An island is a land that is surrounded on all sides by water. Archipelago is the name given to the groups of islands. Caribbean archipelago and Hawaiian archipelago are the two best examples of an archipelago. Tobago and Trinidad are the southernmost islands of the Caribbean archipelago. This example clearly defines what an archipelago and an island is. An island is like the other example can be like Sri Lanka is an island, but the small land masses that we see between India and Sri Lanka that can be considered as archipelago. And island is only the part of an archipelago and island can be called as a subset of an archipelago. Now, in what case we consider island as a part of an archipelago? When there are small islands all together and we have to define one single land body. So then we say that this is a kind of an island but it is part of an archipelago because archipelagos are smaller than island but definitely they are always in groups, more than one. As such, an archipelago is wider and larger than an island. Islands have been divided into 4 types: continental island, tectonic island, coral island and oceanic island. So why I have started with this? Because the next case we are dealing with that will cover different kind of archipelago and islands and also the shores. So how the right between two countries are decided in that respect practically that we will discuss today in the case between Bahrain and Qatar. Because theoretically telling what is an archipelago, what is an island or how the rights are determined between them, how the transit passage is determined between them may not make things very clear. So until unless we take one of the cases that will help us to know or that will enable us to understand that how the international court has decided the matter between the parties and how practically things are working. So this is the case of Qatar versus Bahrain. Now it's basically the dispute between Qatar and Bahrain starts long time back when the British people were in control of all this region. So at that time, actually the dispute arose after the British people found oil and natural gas all across that region. Prior to that also they were rivals actually. Rivals in the sense because the people from Qatar and people from Bahrain, they belong to different tribes and they always used to wage war against each other, war of attrition or we can say war to assert their own might all across that region. And it is not only confined to Qatar and Bahrain, basically the kingdoms of other countries like Saudi Arabia, likewise, were always at war for dominance all across that region. All right. But after the British people found oil and natural gas all across the area, there the cause for that conflict that took another color. All right. So why it is important to initiate this point? Because then many kind of treaties were signed between different parties. Reason being, the primary objective of the British people or the British companies was that how they can explore maximum petroleum by making peaceful negotiations between the parties. Because if they maintain the hostile attitude or they maintained the aggressive attitude, that was affecting the interest of the British people. Why? Because the conflict was not simply confined between their attrition or their supremacy, but they also now were asking for the tribute by the British companies who were taking or let's say those who were dealing with those business of oil and natural gas and exploring all that or drilling the oil and natural gas from that area and selling to many places. So they have to protect their rights. So for protecting their rights, they made different kind of negotiations between different parties and signed different set of treaties. So let's start with this case. Before looking at the various phases of the proceedings, a brief account of geographical and historical background is appropriate. Party I have just discussed now. Qatar and Bahrain are both located in the southern part of the Persian/Arabian Gulf, almost halfway between mouth of Shatt al-Arab to northwest and Strait of Hormuz at the Gulf's southeastern end. So let's see through this map where the two countries are located. We see here this is actually Qatar. All right. All this is Qatar. This is Saudi Arabia and this is Bahrain. All right. And this is Persian Gulf. So mainly all this area is very much rich in oil and natural gas. So therefore, it's not simply, and here you can see small islands, shoals, even archipelagos, somewhat like this area, you can say archipelago area. This is another archipelago area. So there are different type of land masses stretched across this water bodies. And why they have special significance in this case? Because all across the country which will be claiming the right to those land masses, they will be benefited for the reason of finding the oil and natural gas. Had there been no such, not only oil and natural gas, but in some of the places they are very famous for pearls also. So because of this reason, it has been constant place for the tussle between different parties and how the dispute was resolved, because this dispute has to be resolved by determining the rights not simply at the territorial basis or up to the baseline of the parties, but also to the extent of the seaward direction, that is the territorial sea area, the transit passage, contiguous zone and seabed resources also. So how it started? On 8 July 1991, Qatar filed in the registry of the court an application instituting proceedings against Bahrain in respect of certain dispute between the two states relating to sovereignty over Hawar Islands, sovereign rights over the shoals of Diblal, Qatar-Zubarah and delimitation of their maritime areas. So these are the 3-4 main issues that has led to the dispute basically between the two countries. On one side it is Bahrain and other side is Qatar. Now firstly the most important here is sovereignty over the Hawar Islands. Now where are the Hawar Islands? Let's see this. So main island of Bahrain is here and this is main land area of the Qatar. And now, in the last lecture, I was discussing that it is not necessary the archipelago or an island is closer to a particular country, then it will be considered that island or archipelago area is belonging to that particular country. That fact need to be decided or deducted based on the historical control, or it can be it's a geomorphological connections or geographical connections. So that will finally be the determining factor. Which country does have the control over that island? Now here you see the mainland Bahrain is here and Qatar is here and Hawar Islands are here. So if we go by that reasoning that since the Hawar Islands are closer to the Qatar, therefore they must be owning this, or the sovereign control over this Hawar Island should belong to that of the Qatar. But since historically the Hawar Island they had been in control of the Bahrain, therefore Bahrain has always claimed that Hawar Island belonged to Bahrain. And this was contested by the Qatar in this case, that actually it's wrongly interpreted and Hawar Island, that is this part, it belongs to Qatar area, not to the Bahrain. This is the contention raised by Qatar. This is first contention. Next is, let's see, sovereign rights over the shoals of Diblal and Qatar-Zubarah and the delimitation of their maritime areas. Now, what do we mean by shoals of Diblal? Let's see. Shoals of Diblal and Qatar-Zarda. It is the shoals of Diblal. I need to see it in the different map I take here. Now, this is Fashat al-Diblal. This is one area, and this is shoal because it's not the markings that are done. They are not on a simple straight line, but they are broken lines. Why they are broken lines? Because this shows that it is not an island area nor an archipelago area. It's like shoal is the area that remains to some extent submerged in the sea waters. So that is why it is termed as shoals. And this is the another area that remains the reason of contention between Bahrain and Qatar. Now here is Bahrain and Qatar is somewhere here. The other question they have raised is that of Qatar-Zarda. Let's see where is Qatar-Zarda. This place is Qatar-Zarda. So all these are the point of contention. Shoal of Diblal, then Qatar-Zarda and Hawar Islands. These are the three land bodies that are the point of contention, and then they also ask for the territorial boundaries that must be one line territorial boundary that must be created. So what is that one line territorial boundaries? That also let's see like this. That means one stretch that covers this much of Bahrain, and this is all together the boundary between Bahrain, and this all is the claim both the parties make, that there should be one line boundary. So in that reference, if there is a one line boundary, what will be the effect? That many of the Hawar Islands, the part of the Hawar Islands, they will again go to Qatar. So in that reference also it is difficult. And if they extend the Bahrain single boundary, that is the territorial boundary like this, then how it will affect? That means it will affect the free transit passage of this all across this water body. So if let's say the Bahrain's territorial waters, or let's say the water boundaries are extended from here to this point, then all the navigational routes that will be subject to the Bahrain's control, which is not proper, because here the Qatar has to take the free passage. Not only Qatar has to take the free passage, here there is another nation, that is Saudi Arabia. So the free passage of this Saudi Arabia will also get blocked. So that has to be avoided, and neither based upon the division that is done by the UNICLOS can Bahrain claim. Although it has in this regard, they have made the claims, but that will not sustain anyway. So let's go to the issues. Now, firstly, we talk about what is shoals. In geography, a shoal refers to naturally occurring underwater feature characterized by shallow area. In this shallow area is land mass in a body of water such as sea or ocean. Shoals can be sandbars, mud or other sediments, and are typically found near the coastline or river mouths. They can pose navigational hazards for ships and boats due to their shallow depths, which may not be suitable for larger vessels. Shoals can also be important ecological zones, providing habitat for various marine life. Now, this Diblal is a shoal, as we have just seen in the map. But why it is, although like it is partly submerged in the sea water, but why it is important? This shoal is important because closer to this area, there is potential of petroleum, natural gas, and even the pearls. So that is why there is a contention between the two parties, that this shoal area, whether it belongs to Bahrain or it belongs to the Qatar. So both the parties are making parallel claims here. As Bahrain contested the basis of jurisdiction invoked by Qatar, the parties agreed that the written proceedings should first be addressed to the question of jurisdiction and admissibility. Now, since prior to this dispute, there already was a settlement between these two countries based on the negotiations. But who were mediating those negotiations? It was the British people that have mediated the negotiations between them, and somehow that agreement between the two parties that remained functional, or that was like the cause of peace between the parties. But later on, again, when the British people left that region, both the parties started making their claim and discarded the previous agreement. Now, the question arose whether that can be resolved by mediation. So, when earlier agreement was made between the parties during the British time, there was a condition added that Saudi Arabia can mediate for the negotiations between the parties in case of the future dispute. So this time also Saudi Arabia tried to intervene so as to bring both the parties to an agreement. That is, both the parties here means Qatar and Bahrain. But Saudi Arabia could not succeed here. So then they decided, one of the parties, that is, they decided that the matter should be now decided through the court. And that court is that of the UNICLOS, United Nations Convention on Law of Sea. So when one of the parties took the matter to before the court as constituted by UNICLOS, the other party started claiming the jurisdiction, because until unless both the parties have made an agreement to settle the dispute through UNICLOS, the UNICLOS will not have the jurisdiction. Now, when earlier the agreement was made, as I was referring here, that the British time an agreement was made, where Saudi Arabia was considered as one of the mediator to resolve the dispute. It was also stated that in case the parties could not resolve their dispute through mediation, then the matter can be resolved through the court of law. So, since that was clearly mentioned in their earlier agreement, that is the agreement constituted during the British time, so therefore that gave the ground to other parties to refer the matter before the court. But now the other party, that is here, like Bahrain here, has contested the basis of jurisdiction invoked by the government. Let's say the Bahrain was not agreeing to the jurisdiction of the court. Why it was not agreeing? Because Bahrain's claim was that since it was during the British time, this condition was inserted in that agreement, that whenever there is a dispute between the parties, that can be settled either through Saudi Arabia, or if not, then through the court. Now, since the British people have left, that agreement does not sustain, and the court does not have the right. Now, how this can be solved? As per the international law, primarily when the matter is brought before the court has to define the jurisdiction. As per the international law, whenever the matter is brought before the court has to define or determine its jurisdiction, whether it does have the jurisdiction to resolve this dispute or not. Only after determining that jurisdiction, the court can move further or proceed further. So in this case also, now it was the task for the first step for the court, first step for the court to determine whether it does have the jurisdiction to proceed with this matter or not. So how it decided? Now here the Bahrain was the party that was contesting and stating that the court does not have the jurisdiction, whereas the Qatar has invoked the jurisdiction. So the parties agreed that the written proceeding should first be addressed to the question of jurisdiction and admissibility. Admissibility means if the court does not have the jurisdiction to proceed with this matter, then it does not have the eligibility to admission this suit also. About the jurisdiction. The court took the view that both the exchanges of letter of December 1987 between the King of Saudi Arabia and Amir of Qatar, and between King of Saudi Arabia and the Amir of Bahrain, and the document entitled Minutes and signed at Doha in December 1990 constituted international agreements creating rights and obligations for the parties, and that by the terms of those agreements they had undertaken to submit to the court the whole of the dispute between them. So it was something already done, like I was referring to you. It was during the British time they all have agreed. And since the Saudi Arabia was mediator between them, so it was also agreed when Saudi Arabia was trying to settle the dispute that how this can be resolved in case the Saudi Arabia, who was acting as a mediator, failed. So both the parties, the head of both the states, they have already agreed. So therefore, the matter was rightfully sent before the court. The court, after setting the procedural background in the case, recounted the complex history of the dispute. This is one of the most complex disputes. One of the most complex. There are even more complex, but still this one is the landmark. It noted that Bahrain and Qatar had concluded exclusive protection agreement with Great Britain in 1892 and 1916 respectively, and that status of protected states had ended in 1978. Now, how the dispute started? First thing that we need to understand historically, that since both the parties, Bahrain and Qatar, they were they were having the constant rivalry even prior to the exploration of this oil and natural gas. Now, when the British people, they found oil and natural gas, they wanted that there should be peace all across this region. Not simply because they wanted this area should remain peaceful, but reason being because that was in their interest. They wanted firstly to explore and drill the oil from this region, and secondly, the movement of their ship should not get affected by the incident of, let's say, piracy by pirates, or by any aggressive move taken by Bahrain's army, or any aggressive stand taken by Qatar's army. So they both should give free passage to the movement of the ships of the British people or the British company that was involved in exploration of oil and natural gas. So what British people did? They made separate treaty with Bahrain, they made separate treaty with Qatar. And that treaty was for their protection, that in any case, if Bahrain faces aggression from any second party, then the British people will support Bahrain, the Kingdom of Bahrain. But then the Bahrain has to allow the free passage to the British. Based on the similar principle, they also made another treaty with Qatar that if any party does any attack or takes any aggressive move against Qatar, then the British people will support Qatar. But then again, there is a condition that the Kingdom of Qatar has to allow free movement of British ships. So in this way, they made some kind of, they brought both the parties to peace, because they said that now we have an agreement between both the kingdoms, and we want that there should be peace, and it is of no use that commonly we are fighting against each other. So in that way, they tried to maintain peace between the parties. But how this ended? When the British people left, as I said to you, when those colonies were liberated, so that means the validity of those agreement now was of obsolete. So for that reason, both the states, that is Bahrain and Qatar, they wanted that fresh boundaries should be created and acknowledged by the international law. So that situation arose in 1971. Now previously, both the kingdoms, they were involving Saudi Arabia. This time also they involved Saudi Arabia. But Saudi Arabia had also stated that in case it fails, that is the Saudi Arabia fails to resolve the dispute between them, then the matter will be referred to international court. So in the light of that, the matter was referred to international court. Therefore, the jurisdiction that Qatar has invoked for deciding this matter by the international court was justified. The court further cited the disputes between Bahrain and Qatar on the occasion inter alia of granting of concessions to oil companies, as well as the efforts made to settle those. The court first considered the parties' claim to Zubarah, that is again a place I just show you. It stated that in the period after 1868, the authority of Sheikh of Qatar over Zubarah had been gradually consolidated. That it had been acknowledged in Anglo-Ottoman Convention of 29th July. Ottoman is the Turkish Empire. Here I would also like to refer something. When British people, they had created their influence over the Persian Gulf area, the other power that was also high on rise wanted the British influence should be checked. That was the Turkish Empire. At that time, it was known as Ottoman Empire. But both the parties, for certain reasons, decided to, based on certain negotiations. So that was the Anglo-Ottoman Convention of 29 July 1913 that restricted the right of both the British people and the Ottoman Empire for their expansion. So now it was not an agreement between British and Ottoman Empire, but also the sheikhs of that place. Now those sheikhs, they restricted the rights even of Qatar and Bahrain also, because at that time they were protectorate of the British people. It stated that in the period after 1868, the authority of Sheikh of Qatar over Zubarah had been gradually consolidated, that it had been acknowledged in Anglo-Ottoman Convention of 29 July 1913 and definitely established in 1937. So when Ottoman Empire was restricting the rights of Qatar and also Bahrain, they also make it very clear, or they explicitly make it clear to what extent Qatar will have its rights. So one of the regions that was listed by Ottoman Empire where the Qatar will have control, that was Zubarah. It further stated that there was no evidence that the member of named tribe had exercised sovereign authority on behalf of Sheikh of Bahrain within Zubarah. Accordingly, it concluded that Qatar had sovereignty over Zubarah. So one was the area of Zubarah, which was contested in this case both between Bahrain and Qatar. So historically, Qatar was making claims that this Zubarah is belonging to Qatar. Whereas Bahrain stated that that was wrongly concluded during the Anglo-Ottoman Convention, but Qatar was trying to prove that Ottoman Empire has always accepted the claim made by Qatar. And Naim tribe, this Naim tribe that belongs to actually Bahrain tribe, it's part of the Bahrain tribe. They, whether their population was there at Zubarah or not. So they even were living or they were inhabitant of that place, but they were still marginal in number. So that on that basis, Bahrain could not make a very broader claim. Now, where is Zubarah? So this is the place called Zubarah. You see here, it is at the coastal region, and from here you can draw a straight line that goes to Bahrain. So, what was the basis of Bahrain's claim over this area? Because historically, Bahrain, they had sent, the Kingdom of Bahrain, they have been sending their expeditions, military expeditions all across this region, the Naim tribe, and they have tried to assert their might up till this coastal region. But since they were often repulsed by the Kingdom of Qatar, so therefore it was important for the Qatar kingdom to assert before Ottoman Empire that it is their control over this region. So for that reason, Ottoman Empire has acknowledged that the Qatar does have the claim over this Zubarah. Although Bahrain was making claims that the Naim tribe has been living or they are in majority here, but as a matter of fact, the Naim tribe was not the majority tribe here. So this is one such very important aspect, that the claims, although you can see here this mainland belongs to Qatar, but the claims are made by Bahrain based on the historical facts that since there has been military expeditions from the Bahrain from this up to this area, and then there has been some minority settlement all across this region. So I thank you very much for being part to this discussion, and we continue further again on this discussion. So thank you very much, and thanks again for being part of this discussion. Thank you.